So, I guess we'll go ahead and get started. I think there's a couple people who are milling about outside, but it's time to get started. So I'm pleased to introduce our three panelists today, and welcome them back to the law school. All three are W&L Law alums who've gone on to practice in Virginia and, in some cases, further afield. And they bring a range of perspectives that I think you'll appreciate as they speak to us about their experiences in the real world of legal practice and the many ways that solid, efficient research skills can positively impact a lawyer's career at various stages and in various areas of practice. I'll first introduce Judge Rudolph Bumgardner, who also commonly goes by the nickname Duke. Judge Bumgardner is a senior judge on the Court of Appeals of Virginia, and he's had senior status since 2006 when he left the bench after over 8 active years on the Court of Appeals. Prior to that, Judge Bumgardner served as a circuit judge for the 25th Circuit in Stanton for 19 years, including 14 years as chief judge of that court. And he ultimately served Virginia for 37 years so far, I think, by my math, as a judge since 1978. And before his appointment to the bench, he was an assistant Commonwealth attorney for 3 years and spent 11 years in private practice as well. In addition to this, his service to the Commonwealth, Judge Bumgardner has also served his country as a JAG officer in the Army Reserve, the National Guard through 1994, and as an Army intelligence officer on active duty in Europe in the 1960s. Judge Bumgardner has also served his alma mater as an adjunct professor here at Washington and Lee Law, teaching drafting and trial practice between 1978 and 1998. He is a native and current resident of Stanton, right up interstate, and also my hometown. Now, my adopted hometown. And he earned his bachelor's degree from Davidson College, was the editor-in-chief of the Washington Law and Lee Law Review during his time here, and has 2 children who are also followed in his footsteps as graduates of W&L Law and are both now practicing here in Virginia. And next to Judge Bumgardner, please welcome Mrs. Jennifer Dean. She's a recent W&L Law graduate, class of 2012, and she already has a great deal of experience in launching her own practice, the Virginia Immigration Law Center in Roanoke, just this past year. And she was previously an attorney with the Porch Law Firm in Salem, specializing in immigration law. Jennifer is a California native and earned her bachelor's in sociology and communication from UC Davis. During her time at W&L, she developed her professional interest as a student attorney in the immigration clinic and served as vice president of the Latin American Law Student Association. She was vice chair of the Moot Court Executive Board and was an accomplished participant in negotiation, mediation, mock trial, and appellate advocacy competitions. She's currently president of the Roanoke chapter of Virginia Women Attorneys Association and shares a young daughter who's actually, I did not expect that. I didn't anticipate that, but she's very cute somewhere. She shares a daughter with our third panelist, her husband, Robert Dean. And Mr. Dean graduated from W&L Law in 2010. He's practiced in the Roanoke area since, and he is currently in private practice as an associate with Gentry, Locke, Rakes, and more, where he works litigating and counseling in the areas of personal injury, medical malpractice, business, employment, labor, and products liability. And Mr. Dean has also served as a prosecutor in the Felony Crimes Division of the Office of the Commonwealth Attorney for the City of Lynchburg in Virginia. He earned his bachelor's degree from the University of Michigan, where he also worked as a research associate in the School of Medicine prior to law school. It's interesting. While at W&L, Rob interned at the U.S. District Court for the Northern District of Ohio. He is a member of the Virginia Trial Lawyers Association, co-chair of the Blue Ridge Legal Services Pro Bono Hotline, and is involved with numerous other professional activities and affiliations. He was named 2014 Virginia Rising Star Attorney for Plaintiff and Elder Law in the areas of personal injury and medical malpractice. So you have a very distinguished panel before you today. Some great legal practitioners, brimming with knowledge and insights to share. So please help me welcome them. So I think I'll open the floor to each of our panelists successively. I think I'll start with Judge Bumgardner, maybe add a little some insights, a little bit of background that goes beyond what I've given, your thoughts about legal research specifically, and then we also have some questions that I prepared if we want to discuss those, and hopefully we'll also have some time for questions because I think there's going to be some great questions from your audience. So.
I'm going to skip past these questions, and I'm going to touch on them because they bring up a lot of the points that I think would be somewhat helpful to you. Now, I usually pitch this as His Majesty's loyal opposition because I want to shock you into not doing what you're used to doing. And for instance, I'll tell you right now, y'all beware of computers. The computer's going to get you in a lot of trouble. I like computers. I use them all the time. I probably use them more than you do. I have 3 on my desk. And that's at the office. That's not at home. The problem is you think you're going to look up in the computer like you look up on Google or you ask Siri to find some of these answers. And the problem is computer research is wonderful. I was a circuit judge. I rode around and we could only have one book. And usually somebody had walked off with that, so we were trying to conduct major trials with not even the right code book. Now, you take the computer and you've got every book that you ever hoped to have in a major law school library. But it's a curse. That's too much information. You're going to get swamped by it. And what you need to do is you need to get familiar with the law library and books before you leave here. I asked my daughter, about the things that you would do if you were going to be a summer research, and she was with big firms when she was doing interns and that type of thing. She said the first thing I do is make good friends if you're lucky enough that there's a law librarian at the firm, because you're used to going to source materials for research. It's like doing the history papers in undergraduate school. They didn't want you to read a history book. They wanted you to go to the source documents, which I was in English history, and that caused you a problem if you didn't read Latin. You only could do fairly modern English history because you had to go to the original source. You used to go into the sources, the cases. Well, unfortunately with the computers, there are a lot of cases, and I'll tell you this, most of them aren't worth reading. And you don't want to give your, as I got, as a regular case we had, somebody brought in, the sum total, their key case, in their brief, some case out of a court equivalent to what I was on, from North Dakota. Well, I don't give a damn what North Dakota thinks about this. Also, it was a case that dealt with statutory interpretation case. So I have to go find out whether it's worth reading that North Dakota case to see if they have exactly the same statute. Plus, if you're in Virginia, you might as well get used to it. We're from Virginia. The lawyers of Virginia were writing the Constitution and the Bill of Rights before they even found North Dakota. We couldn't possibly rely on that law. But use that law librarian, because you might be given, and this will be typical, a research project of a 50-state survey of something. The reason you're doing that is because your partner has a CLE he has to present, or he's doing something for the bar. They're not going to give this project to one of their fully paid clerks. They're going to get you to do it. Well, go to that librarian, because the librarian very well would know the treatise that's already done most of that, and all you have to do is just update it. Now, the point of this is, before you leave this law school, you go down in the bottom of this law school and look at the books. One thing you can't do with legal research, I do almost all my research now on a computer, but that you can't flip through the books. You can't. When you do computer research, and this is what Sally Wine, who was a librarian here for years, taught me, you have to know that the topic you're dealing with always has these particular words associated with it. And if you do that, then your search inquiry will get you the right answers. But if you think for a second, that's very far into your analysis of whatever you're trying to research. Go to the secondary sources. You want to find out what books to use. If you happen to be in the judge's office, look behind his desk and see what are the books that he has where he just reaches back for them, the ones he depends on. And the first time I did that, I just flopped in it. I'd been in law school long enough to know what a horn book was. But we ended up having to go down to Norfolk for something, and it happened to be the federal district judge was a friend of the family, and he went in there and he came back and talked to us, a great alumnus of WNL also. And I noticed behind him were the books, at this time all the West Horn books, they were the best, were all green. He had 6 of them lined up behind him. As a federal judge, what's he doing reading the same thing they're teaching me about? Well, it's a great way to learn a basic format so you know something about the broad topic, because you can't know all the law. You certainly can't know it if you're going in as a second year or a first year student. You don't have enough exposure. You all are going to have a bit of a disadvantage because you're going to spend much of your third year not doing substantive law. So there's probably going to be a great amount of substantive law that you don't have. Go to one of the base books. That's why I want you to go down to the library and look at those books and find out, eventually find out which books are worth a damn. When you earlier, when y'all were watching these, in particularly the first lecture, you threw up several pictures of different books. I had a gut reaction to each one of them. You know, some of them is, I can't believe they're still ripping off lawyers selling that trash. And that one, boy, that's the one you don't tell your opponent about, because that's where all the marbles are. Now, you have to know that. Now, one of the complications you're going to have became pretty obvious with this. You're going to have to know which of these law resources you have are worth a damn, because all the websites are a little different. Some of them are good, some of them bad. Anyway, use your librarian for that. Now, the other thing that, and this I will shut up with this fine thing, is you got to reverse what you used to do. When you get out of law school, the first thing you do is you pull out that computer or you go find the case. No. First, that's the last thing you do. You go to the statute book, because probably you got these legislatures that meet every year now. They got to show their voters that they're doing something for them. So they got all these extra laws. There's probably a law. And go look for the statute. If you can't find it, you just haven't found it. It's there. And then you get into it. Now, another reason, look at the books. Sometimes these statutes started off as, big long thing, and then 10 years later they chopped it into 4 pieces. But to get the full picture, you have to flip the page back and flip the page over. Also, that gets you to another practical problem. Most of these websites give you the codes, but you've got to get the one that's got some annotations, because you think you're busy while you're in law school. But what you're going to find out is you never had so much extra time. You could research as long as you wanted. You had all the books and all like that. You're going to get to where time is limited, resources, and also that's money, is limited in what you can do. So what you always do is go to the code, but go to the one that's annotated, and that'll get you to the important cases. And then you'll find little tricks of which books will get you there very first. One of the very best ones to use are, all the bar associations have them. They put on seminars, usually statewide and all. The CLE is Continuing Legal Education book. They're some of the best books in the world, and the forms in those books are put in there free of grace, and you look at who gave the lecture, and they're the best lawyers in the state. And here he just gave you the form. If you research and you go find out some of the stuff that's filed, you don't know whether that lawyer is any damn good or not. These CLEs are great. Then there are books like, there's a little handbook of evidence. That's a great book. It gets you to the meat of stuff and gets you there fast. So reverse the process while you're in law school and you've got the luxury of a mammoth library, because you're not going to have books. They're expensive, and the place you rent to put the books, law firms are doing away with that. It's too expensive to have space where you just have books in there, and it's all computers. But flip through those damn books, because while you're trying to find what are the magic words which will always be associated with the concept that I'm researching, while you're trying to find those words, you need to flip the page. It may be in the next chapter of the book. It may be in the book next to it. And you need to find which resources are out there, and then you start doing the stuff that you're paid to do. And that is know which ones are good. There's some of these books, some of these up here were wonderful. Some of them are not. If you're doing criminal law in Virginia, you go back and find the book that's now the sequence to the one that Roger Groot, his picture is right there at the end of that hallway, that Roger Groot wrote, because that's the best book on criminal law that's been written in Virginia in the last 50 years. And if you look at the judge's desk behind it, you'll see Group's book is probably behind his desk. And so you want to be using the same book he does. Anyway, enough of that. I babbled on too long.
No, and you know, Judge Bumgardner raised some really important points that I couldn't agree more with. I'm a little bit more optimistic in terms of using the internet and computer for some legal research, but I think the basics you learn here at WNL and working with the book system in the library, you have access to such a wealth of knowledge information, and learning how to look up those cases, read them well is really important. But what the judge touched upon that I can agree with more is being efficient with your time. As a law student, you still have a lot to do. You're managing your schedule, you're looking for jobs, internships, and you have a lot on your plate. So in finding those treatises that the judge mentioned, those horn books, those practice practitioner guides, will really save you a lot of time because it gives you a great overview of the landscape and the area of law. I specialize in immigration, so I have like 3 or 4 key sources that I go to, and I get my updates, I get my background on cases I'm familiar with, and it has my whole scope of my practice within just 2 or 3 key sources. The sources themselves in book form can be, you know, 2,000 pages, but on the internet, you know, you can search easily, you're familiar with your chapters, and you really develop a wealth of knowledge that way, getting used to these treatises, the annotation guides for the Virginia State Code, as well as other areas that really digest the information for you and let you know what you're looking for, what the keywords and areas are, what the key cases are, and developing that body of expertise. And you will find me with a book on the beach. You know, I prefer hardback, paper copy books. You know, you won't find me with Kindle in my hand. My husband may disagree, but what I really like the iPad for is building a law library. And that's something my husband can talk more about. He instilled that practice in me, and that if you come across an area of law that you're interested in, you think you might want to pursue after graduation, to start saving those materials, and start saving that resources. A great app is called Goodreader, and you can build a law library that way. I use it for my immigration practice. I break it down into international adoption, deportation proceedings, permanent residency, and in each area, you know, I have everything saved from the federal government releases of information, their memos, to case laws in the circuits that affect my practice. And so when I come across something one time in my practice, being so specialized, there's a good chance you'll come across it again. So instead of reinventing the wheel each time to do your legal research, if you come across something that you know is going to be valuable in the future, go ahead and save it. Save it to your desktop, save it to a folder on a file that you can later, you know, save and kind of categorize for future reference. I think being organized is helpful. Even if you don't know exactly now what you want to do, you know, with your legal education, you have a lot of opportunity ahead of you and a lot of fields to choose from. But at the same time, building a law library, a digital law library, I think it's very helpful in terms of being able to search through it too. If you know what a keyword, you know what a case is you're looking for, to be able to access that information really quickly and efficiently. I will tell you from having opened my own firm in the past few months, you know, my time is very limited. You know, I am my own accountant, receptionist, and paralegal, and managing and founding attorney at the same time. So as Judge Bumgardner mentioned, you know, being pressed for time in the real world is very different from the luxury you have as a law student. And what I would recommend when you get out post-graduation is join the associations. I think would really benefit you. There's Virginia Trial Lawyers Association that my husband's a part of. I'm part of the American Immigration Lawyers Association, and typically they may have listservs or they may have, you know, online messaging boards. And through AILA, the American Immigration Lawyers Association, I get a daily update about what are the top 10 articles in immigration news today. And as you probably are familiar with a little bit of the news, it's a hot topic. Things change frequently in my field. And so it's crucial for me to stay on top of the legal developments, to inform my clients, to take advantage of any developments that may aid them. And so with these listservs, I get a daily email that kind of summarizes the highlights, whether there are changes, and typically they'll include links to those sources, those cases, those recently released federal memos. And that's really helpful too. And I would recommend to you guys to join those kind of associations because they kind of offer a shortcut in terms of staying on top of the law. But in terms of building that base, what you're learning right here, right now at the law school is crucial too. Because those are the building blocks. But then when you get towards, you know, keeping that expertise up to date, I do recommend association work.
All right, great. Well, first, folks, thanks for having us today. Andrew,
Yeah.
thanks for having us. We really appreciate it. Let me get a sense of kind of what our group is. If you're a 3L, will you just raise your hand just so I kind of know who we're talking to? Okay, good. 2 L's? 1 L. All right, so we're talking to all 1 L. So everybody here probably just heard my wife say, you know, the luxury of being a law student. You're thinking, my goodness, I'm in my second semester of being a 1L. There is nothing luxurious about being a law student, but really there is. I mean, you have a luxury of time. That's kind of what we're talking about. Everybody in this room is getting ready for your first internship, a placement at a firm, a government agency. Maybe you have kind of like a clerkship or an externship this summer. Maybe you're going to work in a clinic here at the law school. And you're probably wondering, how can I be really effective? How can I do a good job? How can I impress my employer? How can I impress the judge I'm working with? Let me join the judge's comments because I think they are absolutely on point in terms of the mindset that you need to have. When you graduate into your position this summer, or when you graduate from the law school, you are stepping into just an unlimited universe of information. And you go to google.com and there is case law out there, and you could spend days and days and days wading through that case law, as the judge alluded to, or wading through statutes. And the temptation is just to go right to Google and start your research there. But what you need to do, and everybody in this room, when you graduate, you're going to start your law practice in the age of the internet. What you need to do is think about, how can I get to not primary source material as quickly as possible, as the judge talked about, but secondary source material. Now, absolutely, the treatises and the books that you need to find, horn books, I mean, those are still powerfully relevant even in the age of the internet. Okay? But really what you need to think about conceptually is, how can I find curated legal content? That's where you want to start your research. So when I say curated legal content, how many people are on Twitter, if you do Twitter? Twitter is basically somebody is curating content for you, and they give you relevant links and that kind of thing. Somebody's curating content. Or BuzzFeed. I bet a lot of folks in this room are on BuzzFeed or BuzzFeed. If you wanted that your legal research assignment was to find funny pictures of cats, I guess you could go on Google and spend a couple hours looking for funny pictures of cats. Or you go to BuzzFeed, and somebody's already done the work for you, and you could find 22 really funny pictures of cats. And then you don't have to do it on your own. Legal research, conceptually, you should approach your job the same way. When I started a legal research assignment at my firm, or when I was clerking, or whatever I was doing, I did what the judge recommended, which was I found what is the treatise that I need to start with. Now, my definition of treatise, practicing as a young lawyer in the age of the internet, is maybe more expansive than just the books we have in our law library. Another good example of a secondary source of curated information is a law blog. And there are lots of really great law blogs out there that are basically folks that are publishing on their own, and they're publishing with other people, that are giving a good treatment to an area of the law. Maybe that's where you start your research. Maybe you go to Google Scholar, where there are tons of law review articles, maybe a law review article at the University of Richmond, or here at Washington and Lee if you're doing Virginia law, or having to do with a tax matter, I don't know. But find a law review article, and maybe that's where you start your research. And then you'll probably find what are the key cases or the key treatments within that secondary source, and then you get into the primary sources. So that's the main thing that I want to start with. I know we'll have a few more minutes to answer some questions and such this afternoon. But if you leave here with nothing else, leave here with this. Start with the secondary sources. You'll be more efficient. You'll get down to the heart of the matter more quickly. You'll find the key annotations like the judge talked about, or the key cases that you need to eventually research. And if you start with secondary sources rather than jumping right onto Google, right onto Lexis or Westlaw, you'll produce better research memos. You'll absolutely impress your employers because you'll take a kind of a 32,000-foot view of the legal issue before drilling down. It's much easier to fall down than fall up, I guess. So you want to start kind of at a high level and then drill down. Okay? Very good. Really glad everybody's here. We talked to her. She promised she'll be very quiet. If she's not, I'll tuck her under like a football and move down in the hallway. Hopefully she'll be okay.
Great. Well, I will. Are you guys going to be able to stay maybe a few minutes after 4? Is that okay? Because we got kind of a late start. But so I'll just throw out one of the question I think is going to be applicable. And you already all three touched on this a bit, but if you could flesh out a little bit. It's organizing your legal research. You talked about, of course, using the resources that you rely on in the kind of structuring your research approach, starting with secondary sources, identifying which ones, of course, evaluating which ones are the best. But once you're actually kind of in the weeds, how do you, or actually before that point, how do you recommend that students at this point learn a successful, effective method for organizing their research and the approach to it?
Well, you basically are trying to acquire a lot of knowledge, because I guess in summary what we're saying is you need to eventually know where to go to get the right answer and where to get it most efficiently. And some of it's cumulative. I'd like to re-emphasize what you mentioned, and that is saving your past product. Now, this is where a computer helps you greatly. Now, when I started and finally had enough sense to realize, why should I have to, you know, I need to find out what are the elements of first-degree murder. By the way, a good place to do if you have something like that or need to know about what do you have to have if this is a civil suit, go to the jury instruction book. Virginia's got a model jury instruction. I picked this up from one of the lawyers. This lawyer is experienced as ever. Even if he had just a routine driving under the influence case and he had hundreds of them, the first thing he did when he opened the file is he made a copy of the code and threw it in there. If you read that code, it tells you exactly what has to be proved for your person to be guilty. The mental instruction book, what you can do is you go to what they call the finding instruction. Now, that's a kind of a technical term that you know lawyers use to make everybody think, what the hell is he talking about? All that is, it's the instruction that last instruction you give to the jury. And it starts off, if you find A, B, C, D, and he's guilty. And it's always got the word find. If you find, in other words, and it lists the elements. I always love common law burglary. If you find that you broke and entered a dwelling house in the nighttime with an intent to commit, and they'll be numbered, all 5. Put a copy of that in the file, and then when you're looking to see if there's, you know, did you prove the case or the other guy didn't prove the case, see if number 4 is missing. Well, anyway, you eventually do that, but you don't need to redo it every time. Start coming up with what I will call a notebook, because when I started, that's what I had. I had a little old notebook, and I was trying cases over here. And I said, you know, it's crazy for me to have to look up the key case on what is a breaking. You know, I knew this key case, and so I made a note and typed it up. And eventually, I had a set of notebooks of key cases based on the type subject matters as they came to me. And a lot of times, for organizing, I would just open up the Horn book, open up whatever book was kind of the key authority, and use their index. They had a pretty good system. They could redo it later. Well, eventually my notebooks were this big, and then we came along with computers. All of it can go into the computer, and you don't even have to do that, and you can do free text search and come up with the stuff that is a lot better than thumbing through it. Save your product. Stuff you can do now. I mean, you see something good, you just clip it off an article and put it into your computer research. You pull out your phone and take a picture of some document and throw it in there. You cut and paste. You don't have to dictate. You don't have to do the real laborious thing is type the damn things yourself. Or worse than that, try to read your old handwritten notes when it's no longer legible. Come up with that in the different areas that you practice in the different sub-areas. What you might put in now, you might never use again. On the other hand, it might save you a whole lot. And this will include checklists. You know, what are the checklists you have to have before you can get in a second-hand document when you don't have the original, best evidence rule and all that kind of stuff? What are the elements of this cause of action? What are the elements to get an affirmative defense? All that kind of stuff. It's not just putting a copy of your brief, but it's all those little things. Or you clip that form that was real good in that CLE. And it brings me to the other thing that I also get involved with the bar associations. That's where you make some of the very best contacts. These books are cheap. They give them to you when you go to the classes. You got to go to the classes to keep your license new. And you also end up talking and becoming good friends with the guy who's the best lawyer in the state on this topic. And he'll be perfectly happy to have you as a lone lawyer pick up the phone and call him in Richmond, and he'll sit there and talk to you and never think that this is something that he ought to send you a bill for. It's just what you do. Somebody help me. I'm very happy to do it. And you make the contacts. Or you have a client who has something that's over your head, but you have to know somebody that you can trust to send them to. Those bar associations, get involved with the bar. It's the best way of getting tips and help. You know, I mentioned the bit about asking the law librarian if you have one. That's the other advice law firms didn't have libraries big enough to have law librarians when I got out. But so the advice they gave you is, don't work, ask the clerk. You find out about the court clerk. Because if you want to know what was the best form that's been filed in his court, you walk over to ask the clerk and say, John, I got an assignment, my boss, and he's a real SOB on Wednesday because he wants to get on the golf course, and he wants me to come up with a draft of this kind of suit. Have we had one of those? And he said, well, why don't you go back and look under Smith and see if there isn't one in there. And you come up and you've got the best law, you've got somebody else's law firm. Anyway, get friends with the clerk, get friends with the librarian, whoever's the magic. But in the Bar Association, they're wonderful contacts. You feel when you start, oh my God, I'm not going to go down with all those silk stocking people and all like that. They used to sit out here at Goshen Pass and drink beer and sit in inner tubes too. And they love to help because somebody's helped them. When you start off, you're going to get usually in the statewide organizations, and get in a couple of them. They waive fees for you for dues for the first couple of years. Take advantage of it, save up a little money, go down to the annual meetings and just get involved. And then you'll end up with a great network. I've got some of my closest friends I grew up with in Stanton. And the only time I ever see them are at the annual bar meetings because they're in a different town. And they're great contacts. But that is as good a tip as you can get in law school. Get involved. They have young lawyer meetings. It's a lot of fun. They have all the same things, the best contacts you'll ever meet. And then it turns out these guys, some of them know a whole lot. And they're happy to help you and can bail you out of a lot of problems.
If I could just jump in to add one thing to what the judge said. In terms of saving your work product, something that Jennifer mentioned and something that we both do, and it may not help you this summer, but it'll help you 3 years from now, it'll really help you 5 years from now, which is because everything's electronic now, like the judge said, you ought to get in the habit of saving the work that you do. If it's proprietary work or it's an internal memo or whatever, you probably can't save it. But if it's a case that you've marked up and you've highlighted, and it's a PDF, you should save it and keep it and use it for future use. Let me give you a really good example. So I still have an electronic copy of every outline I wrote at W&L. It's on my iPad. I'll travel to Virginia Beach for a deposition. And sometimes there's that random question that I have that I know our torts professor dealt with, or I know our criminal law professor dealt with, or whatever. And I store that stuff and I keep it and I have it. It's much better than writing it on a piece of paper, printing it, and sticking it in a file box somewhere. The benefit of practicing in the area that you're going to practice in is that you can store everything that you ever generate. Any case you ever read, any letter you ever write, any memo that you ever do, any treatise you ever get from VTLA or immigration, whatever. You open a Dropbox account if you don't already have one, upload it, create folders by subject, and start saving everything. When I started my career, Jen was 2 years behind me, so we were living in Lexington. I was commuting in each state of Lynchburg to work as a prosecutor. I still have cross-examinations that I outlined in a larceny case, for example. And it's saved on my iPad because I put it in Dropbox, I sync it to my Goodreader app, it's stored locally. I could be anywhere at any time, and it's very common, and we have 60 lawyers in our firm, for other folks to walk down to my office and say, Rob, can you put your finger on this answer? And I have a reputation at our firm because everything that I've ever read or ever done is now organized on my iPad. And really quickly, with a quick click of a button, I can put my finger on something because I've done it before. And I've just kind of be a digital pack rat. I mean, you can afford to do that because it doesn't cost anything. It's all free. Just use PDFs and Word docs. Save that stuff in the cloud and have it forever. Why not? You will then get the reputation as the go-to lawyer that has their hands on whatever the key source material is. You'll be the one accumulating all that information, like what Judge Bumgardner said. I recommend doing that now. You're one of them. I mean, start now. You'll look back and benefit from it years from now. I really strongly encourage you to do that. And it's very easy. You open a Dropbox account. You sync everything to Goodreader. You either have it on your laptop via Dropbox or you have it on your iPad via Goodreader. And it's really easy to start collecting now. As lawyers, we don't traffic in paper. We traffic in information. That's why people hire us. So the easier and more organized you have that information, the more valuable it will be to the law firm you work for and to the clients you represent, whether you're a solo practice or in a bigger firm like I am. I just want to add that, though, because from a technological standpoint, it's really easy to do exactly what the judge is talking about.
Let me throw in one caveat on that. When you're doing that as an intern, be careful that it's a product that it's okay for you to take away from the office, because you can get into ethical stuff.
No
you know,
question.
if it's somebody's personal stuff, it might watch. Just always be careful for that, because the computer age creates a lot of pitfalls for practicing when you get to the privacy, and particularly if you're temporary with a firm and all like that. And just things come up and you see and say, oh my God, there was the grace of God, go, I could have done that, didn't think. You know, the big thing about whether you can put office stuff up in the cloud, because, you know, all this. But just be careful about that. As long as you're careful. One of the greatest things about going to W&L is the honor system. That's the best training you can get to be a good lawyer, because you've got to be honest. You can't lie. You can't cut. And I mean, it's just natural. You don't cheat. And just be aware of that, even in something as simple as that computer. Oops, is it proper for me to be taking this thing home? And it's easy enough, because it's generic stuff and stuff you do that doesn't have names and all that kind of stuff. But you can get in a lot of trouble real quick. Be careful on that stuff.
Yeah, don't walk out the door with client information, obviously. But if it's a treatise or a secondary source or an article or a case that you've already marked up, it's public information, you'll have to save it. I mean, that's the kind of stuff I think the judges talk about in terms of accumulating.
I want to touch on the organizations that Judge Bumgardner mentioned, and to encourage you guys that when you graduate, you don't have to wait 5-10 years to join. You know, I graduated in 2012, and I serve on 2 Virginia State Bar Committees, Access to Legal Services and Legal Technology, along with my husband. And in those organizations, I get to know so many older practitioners. And as Judge Bumgardner mentioned, they are a wealth of knowledge, and they're eager to help you. You can find a ready source of mentors through the Virginia State Bar, through other organizations. So I do recommend that upon graduation, you reach out, join those organizations, make yourself available. You don't need to necessarily wait 5-10 years, 15 years to accumulate that knowledge and that practice. As long as you're available and ready to work, that there are a lot of people who are willing to help you. To get back to kind of the legal research, and when you have your first assignment, you know, what I found, you know, when I was summer associate at a national firm that was based in Richmond after my 2L year, and, you know, upon graduation, I did a lot of legal research for immigration because it was a new area to me. I would find that my employers or my supervising attorney or the partner would ask me not so much a question framed in legal terms, but a real world situation they have with the client, and they want a certain outcome. And I can best give you an example of something I come across in my own practice. In immigration, for example, I may have a client who was previously deported in the United States. Maybe they re-entered the United States and then received a cocaine distribution conviction. And so that's my situation. And what my research topic would be is, you know, what reliefs to deportation are available to him now. So instead of something that's kind of high-minded and framed nicely, I found in my experience that senior partners and associates would ask you, you know, they want a certain outcome based on a certain set of facts. And so, as Rob mentioned, I think it helps from, you know, even if you're faced with such a specific situation, the best thing to do is confirm the scope of your research assignment and confirm with that supervising attorney or associate, a senior associate, what you're researching. Ask them to repeat it, write it down. One thing my husband, again, you know, told me when I was a summer associate, he's one of my all-time mentors, but send that senior partner an email and say, you know, thank you for meeting with me this afternoon. This is what we discussed. I understand you want me to research X, Y, and Z. And here's the date that it's due. And then one thing that Rob recommended is, you know, turn in that research assignment a day or two before, if possible. You come off looking really good. You've developed a great reputation. And by confirming that research assignment, you can go off a lot of different tangents. But by narrowing down that focus and confirming that focus with the attorney who's giving you that assignment, or the judge, or what have you, that you really put yourself in a good advantage from the get-go. The next step I'd recommend is, again, look at those treatises, kind of start from a bird's eye view with the area of the law. If you're researching a car accident situation, start with car accidents in Virginia, whether it's the Eastern District, the Western District, and then narrow your focus down until you find a similar set of facts, focus on those keywords, and then you kind of drill down into the law and the substance that you need to adequately address your research assignment, to write on it, to draft that memo, and to turn in a good work product for your supervising attorney or judge or government lawyer, whoever you might be working with. That's what I recommend.
I see we're after 4 o'clock. Y'all are, it's a Saturday, so I don't want to keep you much longer. I don't know if we have any.
Let me say one more thing about when you get to the cases, when you mention the facts. And this is a problem I see in a lot of the briefs I get. And I think it's partly the way we study cases. And we study cases and we read what the judges say. Well, I can tell you, there are a lot of cases out there that ain't worth reading. And a lot of the time what the judge says isn't what they did. Take the case and it's the facts. That's what you're looking for. You're looking for the case that says if fact A and fact B and fact C happen, D is what is the legal result. And what you would love to do is come down and you have a situation where you've got fact A, fact B, fact C, and you find a case that says D is the answer and that's the answer you want. Analyze the cases to the facts. Don't just look at the wonderful words the judges say, because a lot of stuff, a big article by the Supreme Court in the Washington Post the other day about this, they say these things and then everybody's trying to figure out what happened. Well, you want to know what was decided. That's the key. Get the facts. Get the facts and try to find it, and then compare and contrast your facts if they're different from that. And don't just take big quotes. That's what I see as one of the curses of legal research. People write and they find a wonderful quote and they cut and paste it, and that way you don't even have to type the damn citations because it's already in there and it's done right and you assume it's been done correctly. You just cut and paste and you plop it in there. And it's brilliant. And then you read the case and you say, it doesn't have a damn thing to do with that. This case doesn't have a thing to do with that. And that's another point that I think is awfully important and it seems to be missed all the time. The procedural context. I hated the part when you did briefs in law school, you had to write the procedure. It never made any sense, didn't understand any of that. By the way, if you're going to practice in Virginia, you better take the Robin Woods procedure course if you're going to take the bar exam. If you go into another state, you better find as much of the state procedural law if you want to get past the bar exam. But the procedural context turns out it just came, it haunted me. I hated that. Got out of law school, wasn't going to worry about that. It's a big difference as to whether your case really has much control if it was a decision made on a motion for summary judgment before there was any trial, as opposed to if it's a decision made after a full trial. Because you might say, oh, this is a brilliant decision. It says this is what you have to prove. This proof will give me a winning case. And it's a motion on a summary judgment. They accepted as proven what was in the document without any question as to whether it had been proven. It's a completely different, and it has a completely different weight you give the case. So, read the cases and compare the facts. Don't just look for the pearly quotes that you can cut and paste and give it. It looks good, but then doesn't have damn thing to do with what the case is. It's in there, no question. It wasn't a misquote. It's just it doesn't relate to the facts. And also, say if you haven't learned the hard way, which is the way I learned it, the procedural context is the reason it's at the top of a brief. It absolutely controls everything that you learn from what comes below it. But so get that part of it too.
Folks, thanks for having us today. Andrew, thanks for having us. I don't think we have anything more to add. We love W&Ls. Feel free to come. Everybody's probably getting ready for finals, and then you got right on for large and all that in the next couple weeks. When things settle down, it's easy to find us all, I think, online. And we'd be glad to help anybody, have a successful summer and a successful kind of law school career. So feel free to get in touch. But thanks for having us today.